Okay, looks like we have everybody on. Welcome everyone to this coffee shop session for ABA and Russian Arbitration Association. Contrary to what you see on my screen, I am not Victoria ABA. I am Drew Holiner of Monckton Chambers, and I practice in England, Russia, and a few other places. And I have with me my co-host and colleague, Jessica Fay. Perhaps, Jessica, you could introduce yourself.
Sure. Good morning, good afternoon, everyone. And to Drew, maybe I think it's very odd hour for him. He's now based in California, so this is very difficult hour for Drew. I'm Jessica Fay, International Arbitration Partner of King & Wood Mallesons. I'm based in our China office. I've been doing international arbitration for the past 25 years or so, and that's the only thing I do. So I'm very pleased to co-moderate this session with you. And although I could hardly see any of you, hopefully you can turn on your camera to let us to see you, so that this doesn't look like we're talking to empty brain.
So I've put up on the screen, as our organizers have suggested, list of our sponsors. Please do have a look at that. That's what keeps these things going. And at the same time, we have a short poll to sort of get things rolling. I'm going to send it around, and if everyone could provide an answer within the next 5 minutes or so, that would be good, and then we can close it out and share the results with you. So our topic today is winning tips in documents-only arbitration, and I was hoping we would send this poll around a bit beforehand, but it appears we need to do it within the session to get it sort of gauge everyone's experience in this area. But to start off, I would like to invite Jessica to discuss the first topic on our, or question on our framework. And what is documents-only arbitration, Jessica?
Okay. Hi, everyone. Now I can see Doreen, which is nice. See one participant who will be an active participant, I guess. Okay, just to start with, we are given this topic like for the winning tips for documents-only arbitration. So first of all, we do need to decide what is documents-only arbitration. To put it very simple, I think that is, as what it says, documents only, no hearing. Basically, in the arbitration, if you are using or adopting documents-only arbitration, meaning the arbitrators at the tribunal will only examine the case by looking at the written submissions and read documentary evidence, and probably including witness evidence in writing, but there won't be any physical hearing or virtual hearing to examine the witnesses, for example, and wouldn't be opportunities for counsel to present their case orally. So this is pretty much what is called like documents-only arbitration. You only get documents. And of course, this is something probably, even this concept and method has been available for many years. Frankly speaking, even in my, past 25 years experience from arbitration institutions, as counsel, as arbitrator, documents-only arbitration is not that often used, but I think now is probably something, we should think more to use as an effective means to resolve some of these suitable disputes. And I think we are going to discuss what are suitable cases for documents-only arbitration. I think this is just to kick off. Drew?
Thank you, Jessica. So Well, one of the points I had sort of set out to get up our discussion is a bit of discussion of cultural attitudes and approaches of different legal systems and arbitral institutions to documents-only arbitration. It's fairly common in most major institutional rules that a documents-only arbitration is subject to the unilateral right of any party to request an oral hearing. Unless they have agreed in advance, there should be a documents-only arbitration. Might mention some of those examples. We have it in the model law, UNCI trial rules, LCIA, ICC, SIAC, Hong Kong. Prague rules also has this right, although it sort of tends to discourage oral hearings and encourages the parties to engage in documents-only arbitration. And this sort of reflects a sort of common theme where in many jurisdictions, oral hearing is viewed as something that's fundamental to the right to a hearing. It includes the right to an oral hearing. And in some jurisdictions, even the New York Convention, the right of a party to present its case has been interpreted as giving right to an oral hearing, although it's not expressed. But this isn't necessarily true in all jurisdictions. We have some examples in America and Germany where parties have had a documents-only arbitration and the resulting award has been challenged and the courts have refused to set them aside. We also have, interestingly enough, in England, where for a long time the common law has recognized a right to an oral hearing. The Arbitration Act 1996 actually says that the arbitrator can decide whether to have an oral hearing, and that's in section 34(2)(h). However, it's few institutions would, or most institutions, including the LCIA, do recognize the right to an oral hearing. Whether that is something fundamental or not has come before the European Court of Human Rights in a case called Scarth in the UK, in an arbitration, in a case where an arbitration was held without a public hearing or a public oral hearing, and the court decided that was a violation of Article 6, which might seem a bit of a surprising outcome. But that was a case involving a compulsory arbitration as opposed to a voluntary one. So there is a little bit of different approaches. As far as practicalities are concerned, and we'd invite others to share their experiences, but you know, we tend to see in England and other common law jurisdictions, there is a high value placed on oral advocacy, the importance of it, the importance of engaging with the arbitrators, and being able to persuade and present one's case to actually be able to cross-examine witnesses. Whereas other legal systems and their culture might be a bit different, are more skeptical of the usefulness of oral advocacy, skeptical of the value of witness evidence. And oftentimes we see in those types of jurisdictions, when oral hearing is held, parties will get up and just read their written submissions, and that's about it. So we'd like to hear from others' experience of how they value that, and also the approach that had been when they dealt with the documents on the arbitration. Let me just, I've got a few more attendees to put in here so we can have people speak. Just a moment. Ask folks to bear with me a little bit here. I've, of course, done Zoom, but not a large session like this with Zoom before. So. Okay.
So feel free to raise your hand if you want to, make comments on any of the issues.
So we only have six people that voted on the poll so far. I see we have about 17 people in session. I don't know if everyone has seen the poll, but please feel free to go ahead and fill that out. So to get the ball rolling here, perhaps we might put out a topic to the group is what types of arbitrations are suitable or best suited for documents only arbitration in your experience?
For those who just joined, can you also do the poll? You can just, click on the poll icon and then answer the poll questions, please. Currently, we only have 6 answer the questions.
So as far as suitability of certain cases for arbitration, I think Doran, you had mentioned something in an email to me yesterday where these types of documents only arbitration are common. Would you like to share that with us?
Yeah, well, I would mention that the LMAA, which is a very important London institution, the London Maritime Arbitration Institution, Arbitration Association, actually handles more arbitrations annually than the LCIA, ICC, SEAC, HKIAC put together, believe it or not.
Mm-hmm.
And according to their website, 80% are handled on a documents only basis. But it may be, no doubt that varies from year to year, but a very high proportion of them are documents only. And the other extraordinary thing about the LMAA is that the arbitrations are ad hoc. They have rules and they have a procedure and they have a variety of rules, including small claims rules. But it doesn't have the stamp of an institution on it. And the reason is that the LMAA is essentially there to serve the maritime community. And these are people who do business with each other the whole time. They don't really want to get into bitter squabbles, but there are all kinds of cases that come up. One of the most extraordinary things about the development of commercial law in England and many other places is that a high proportion of the cases that are important in making the law are maritime cases. And many of the top chambers in London that are known for commercial work actually started as shipping specialists. And virtually all of them do some shipping work, even now. And again, a lot of this has to do with the complexity of the cases, the legal issues involved. But not all of them are very complex cases. Some of them are actually much simpler cases. And the parties are just unable to resolve them themselves because there may be an issue of law and differing points of view on it, and they just need to get it resolved. So they go to the LMAA, they get some of the process started, they get an arbitrator or a trio, depending on what their agreement provides, and they get it done. And the idea is to do it quickly, cheaply, and effectively. And they take a great deal of pride. They've been holding seminars and holding remote arbitrations, which they very much encourage. That's mainly in the maritime community, and there are other institutions that do maritime disputes, but LMAA is quite remarkable, and it's very suitable for the kind of arbitrations that they do. So I think that that's a useful thing to put in the mix because it's very different in other areas. And thank you for calling on me.
Yeah. Yeah, and what seems to drive that? Is it because it's sort of you know, industry turnover, cookie cutter type cases, or is it to save on cost, or is it because the nature of the dispute really doesn't lend itself?
They're not. They're not cookie cutter cases. They're
Mhm.
cases. I mean, you have to bear in mind you've got ships going all over the world,
Mhm.
and all kinds of things happen with cargo, with damage, with collisions, with I mean, this is a very live. It's one of the biggest industries going, and they aren't all big cases. A lot of them are actually relatively small, and they just need to get sorted out. And that's what drives it. And the LMAA is a peculiar institution in that it tends to be it tends to be driven by a relatively small group of people at the center of it who actually understand the industry, and they're very keen on having experienced people, not necessarily lawyers. They're very keen on having non-lawyers, although obviously there are a lot of lawyers involved.
I understand for maritime disputes is unique because actually I think that's pretty much the kind of the very classic and traditional arbitration meaning you get someone who has the relevant experience and knowledge and who can just, you know, make a decision quick on the spot rather than going through a lengthy process like the, you know, the commercial arbitration today. So it's more for efficiency and of course cost and speed purpose, and I think just to resolve the issue quickly. I think that's pretty much the arbitration. Being arbitrary sometimes we think, you know, it really relates to the origin of arbitration.
That's correct. The other group that I know of is something called Prime Finance, PRIME, with dots between them. That is a securities industry specialist group that was set up. It's essentially was set up by the ISDA people, the swaps and derivatives people, for similar reasons, because they have difficult issues, sometimes involving huge amounts of money, and they have to go on doing business with each other, and they don't want to take even 2 years, let alone 5 years, going through a long process. What they want is somebody who's really expert on is the documentation and the deals that people do in that industry, who can come up with the decision. And they recite instances in which they've got through the whole process within about 3 months, and I'm sure in some cases that can be done quicker. So that's a complete opposite end from the maritime business. But it is very important. They're based in The Hague. They've only been established for something like 10 years, but it's growing very rapidly, and they have a great annual conference in The Hague if you want one to attend.
Thank you. But before we move on, might I just ask, I see a message in the chat that folks that have been promoted to panelists are unable to vote. Is that the experience everyone is having? Because we only have 7 votes on the poll.
Yeah,
I don't know.
That's the experience I had. Yeah.
I don't know if it's possible to demote yourself and vote, and if it isn't, then probably at some point before we get to the end, I'll have to do it for you so you can vote. But so is there anyone else who would like, before we move on to another question, would like to share their experience on what sort of arbitrations are suitable for documents only? Well, one interesting situation came up in arbitration I was sitting in, and I'm sure it's come up with others as well. I see that a number, even the small number that we have that have voted, there's several with experience. 2 parties. One party, they haven't agreed to documents only arbitration, but one party says, we can't afford all this expense of having an oral hearing. We don't think it's necessary. We're not going to show up. we're not going to short the arbitration. Just consider it on the papers. Approach of the arbitrator. Thoughts? Would anyone like to chip in on that scenario?
Virtual.
What would you do as an arbitrator in that situation?
I'll suggest a virtual hearing.
A virtual hearing. So you would have an oral hearing with the participation of only one party.
So if the expenses, true.
Yeah.
So if it's at the expense of one party, you know, and it all involves traveling costs and, you know, all those representation costs, then it could be a middle ground. It could be something, say, you don't need to have a full-blown hearing. You could have it virtually, or for example, if you want to cross-examine witnesses and experts, you could also do it virtually. It would not involve much costs, I believe, other than the preparation for the hearing and you know, for the counsel. But isn't it in the rules, if any party demands a hearing, there should be a hearing?
Most institutional rules, although as we discussed at the beginning, at least in England is one jurisdiction because of the Arbitration Act. If we had an ad hoc arbitration or a theoretical institutional rules that didn't provide for the absolute right to an oral hearing, the arbitrators could decide not to have one. I mean, what sort of problems would that pose, though, that the arbitrators would need to be sensitive to? Having an oral hearing with the participation of one party, essentially, what might be good practice for the arbitrator in that situation? Any thoughts?
Hi, if I may jump in.
Please do.
It's Laurence Ponty from Switzerland. I just wanted to share an experience I had last year with you. I was an arbitrator, a sole arbitrator in a case subject to the SCHY rules, so the Swiss Chambers rules, and the proceedings were conducted under the expedited procedure. And the rule is that there should be a hearing unless, of course, the parties agreed to have the arbitration conducted on a document-only basis. The claimant asked from the very beginning that the proceedings be conducted on documents only. And I asked on several occasions to the respondent whether it agrees to this. And the answers from the respondent, who was the representative of a company, but not represented by external counsel, the respondent did never clearly answered to the question. So it was a bit difficult for me to make a final decision, and I had no choice in the end but to provide for a hearing. And I ordered that a hearing took place. I said that would be a very limited in time hearing, and it was conducted by telephone, actually. And I didn't really expect the respondent to join, but in the end it did. And that was extremely useful. It was not a long hearing. Again, it lasted about 2 hours or so, but this is finally at this point that the respondent made an argument which he never raised before and which I took into account in my final decision.
Yeah, actually, I think I do sit as arbitrator in a few documents-only cases, and also with default cases where the respondent is not participating, because I think it's still kind of the default position for most, even if for arbitrators to consider. even if the respondent is not participating, at least in, for example, in jurisdictions like China, it would be fair to still conduct oral hearing, because you know, normally or in principle, even if the respondent is not going to send a lawyer or doesn't want to engage a lawyer to present its case, it still has a right to be heard during the hearing. So once you have, you know, set up a hearing, that is an invitation to the parties to join. They may just show up to present their case orally. So I think that's kind of the thinking behind having an oral hearing always, even if we haven't heard from the respondent for, you know, before the hearing. But still, on the other hand, you may think it also works well if the respondent doesn't really care to show, to appear on record. And why should we not use more efficient way by having the documents only method?
So say we're in the documents only arbitration. From the standpoint of counsel and arbitrators, what would be a sort of best practice to, you know, to make sure that the documents only goes effectively, you know, and avoid some difficulties that could crop up along the way in a documents only case? Any thoughts folks would like to share on that from their experience? We see on the poll, although not everyone has voted, we do have a number of folks with experience in handling such cases. You know, one thing to, of course, think about is that in documents only, you know, we don't have cross-examination usual way, putting documents to witnesses and so forth. So one thing that might be considered by arbitrators is to, at the outset, have a protocol for challenging documents, a procedure by which parties can, you know, instead of simply saying, oh, it's all disregard that document or it's fraudulent, to have actually a procedure putting the onus on parties to challenge documents and to present the basis for that. Any other thoughts from participants on that? What would be effective, needed to organize the documents only?
Documents only, I think, is probably more civil law tradition. Well, because in civil law countries, jurisdictions, documentary evidence will normally be given much more weight than witness evidence, because typically civil law background judges and arbitrators do not, you know, think that witnesses will add much, or they sometimes think witnesses can lie. So that's pretty much why documentary evidence is more important. So with that, actually, documents only arbitration in civil law countries, civil law jurisdictions, is probably more acceptable. And so the question is, you know, how to make a documents only arbitration more effective? If, let's say, parties agree or the tribunal has ordered documents only arbitration, whether common law background lawyers will feel that they're being disadvantaged in documents only arbitration?
Sure, if I may, I believe that there shouldn't be a solution like one size fits all. There might be more evidence-heavy arbitrations with witnesses and experts, technical documentation, etc. But a majority of arbitrations, which we omit to say, are small claims. There may be 100 and 200,000 US dollars in interest. And those might be very simple sales of goods contracts, or simply delay in payments, delay in shipments, etc. Those which do not require or may not require expert evidence or witness evidence. And if you look in, if you look into the statistics of the London Maritime Arbitrators Association, you'll see that 80% of awards are actually issued on the basis of the documents. And those are not simple claims. There might be insurance and reinsurance claims, shipbuilding claims, etc. But still, you have 80%. Why is that so? Well, first of all, because there is certain. Well, this is an industry-based arbitration, and I believe that those representatives and arbitrators who actually are involved in those cases are well-established professionals in the field of maritime law, etc. Secondly, there is trust in efficiency in arbitration in that type of industry, and efficiency in terms of costs and time foremost in maritime disputes. When saying how to structure a document-based arbitration, I think one should really look into a particular dispute, where documents may suit one dispute, they may not be enough in another.
One thing that's out there that folks might want to keep in mind, if you aren't aware of it already, the Chartered Institute of Arbitrators has put out published a guideline on documents-only arbitration proceedings. You can find it on their website. I might just quickly, if I can do here, show it on the screen. So I don't know if folks can see that. It's not very long, but it has some good tips in there. I mean, obviously, one of the points that there's a reason why the possibility to have an oral hearing is often regarded as a right, and that's because it gives the possibility to engage with the arbitrators, understand what they're thinking. It also, the flip side to that is there's a greater risk for arbitrators in the documents-only arbitration of deciding matters or taking a decision on things that haven't been properly aired out before the parties. So it's quite important. One thing, at least, I found in my practice in documents only, whether by agreement or by default, because you have a non-participating respondent. Often that can happen if you have a non-participating respondent. The claimant will be quite happy to proceed without an oral hearing. But one tool I've found useful is to send lists of questions to the parties on all the matters that are within consideration. And number one, that ensures that that there's a record that the parties have had an opportunity to respond, including the non-participating party. And it also it can protect the arbitrator that the parties have fair notice of the issues that are going to the award. So that can be quite helpful. And in fact, even if the arbitrator spots points that perhaps have not been raised by a party, many institutional rules like Hong Kong and even in England give a fair amount of leeway to arbitrators to take the initiative in investigating certain cases that perhaps might be less familiar in an adversarial system. Any other thoughts from the participants on best strategies for documents only, pitfalls to avoid?
Before we talk about the pitfalls, maybe I'm thinking loud of my two of my cases. Actually, I'm having virtual hearing scheduled for December. But those two cases, when you think, look closely, actually, I think those are really suitable for documents only arbitration. One is actually with a debtor or respondent in, a southeastern country. Actually, there was no real dispute in terms of the debt. It has been acknowledged, but the respondent has been very, has been trying to prolong the process by using everything, but not even substantively participating, but just send like emails to say, when the tribunal invites, because we requested for as claimant for potential, documents only arbitration, because this is a very straightforward case. It's just about the debt the respondent has already acknowledged. And then the guy just said, oh, isn't right that I'm entitled to a hearing. And then, that's it. And then in that kind of extreme case, the tribunal has set up, a virtual hearing for that, but it's very likely the respondent is not going to participate at all. So what's the real point of having a virtual hearing and scheduled for 3 days with no certainty that the respondent is participating? That's one case, very straightforward case. And the other one is actually the amount in dispute is actually not big. The total contract value is only just over $60,000 US. And, and then 3 arbitrators appointed, and we requested as, although in that case, we are actually respondent, but the claimant was trying to make frivolous claims and then demanded a hearing. But actually, I'm always conscious that for a contract value of that little, 60,000 US, does it really worth 3 arbitrators to have a hearing for 2 or 3 days? And actually, well, it's a international sale of goods contract. It's not something complex. Very little witness evidence. So I do think in these cases, for efficiency and cost purpose, it's very much documents only arbitration would do better than those traditional like arbitration with hearings.
Okay, so I'm putting in. I figured out how to change folks back to attendee, so you can vote on the poll. So please go ahead and do that, because I'll try to change you back. And if of course if someone wishes to speak, I think you can still wave your hand or send me a message in the send me a message in the chat. So sort of reverting back to a question we discussed a little bit earlier, what do we do when one party is insisting on documents only and the other party is not, or they say they want a hearing? Obviously, under most rules, the answer is rather simple, that you must have a hearing, or you risk having the award being set aside. But just to illustrate some of the problems that can arise in that situation, I might just give a couple examples from practice where one party said there was a case with there was several affiliated defendants, and one of them was saying they didn't want to show up at the hearing. They thought it was unnecessary, and they supported everything the other defendants said. Then at the hearing, one of the defendants, or actually respondents, represented to the court, or represented the tribunal, that they were authorized to speak on behalf of all the respondents. And then after the hearing, that respondent challenged that and began to complain about decisions that were taken. They said things were discussed that they weren't aware of, that were raised for the first time, and so forth. You know, in those sorts of cases, in particular, a similar situation I had in a telephone hearing where one party refused to show up in a procedural hearing. Quite important that the arbitrator ensures that there is a record. There's a record not only of a clear record of the party being timely invited to the hearing or the telephone hearing, as the case may be, but also it's good practice to have a stenographic record, or at least some sort of note of what has been discussed that is immediately circulated to the non-participating party, so as to head off possible procedural vandalism, I would describe it, of a party starting to complain about the arbitrator and a party discussing things out of their presence. So, which obviously that you don't have that risk with correspondence circulated to all the parties. Also important that what is discussed at any hearing with telephonic is also made clearly pointed out to the non-appearing party to protect the award. Any other thoughts on tips, pitfalls? That's sort of a half documents only. I think I've just about got everyone as demoted everyone again to attendee. And so hopefully we can get that poll finished now. And in our last few minutes, sort of discuss that. So we have, all right, we have almost everyone voted. We just have a few stragglers. One more.
Yeah, actually, it looks like, you know, we have people are quite experienced in documents only arbitration.
I was sort of perhaps a bit surprised by that, given how relatively uncommon they are, but
I think we are on the last question. Actually, most people, 82% think parties should always have a reserved right to demand an oral hearing. Would that still be your answer in the case I just mentioned? Being a respondent who's not cooperative, who doesn't want to participate in anything, but still thinks he is entitled to an oral hearing. Would arbitrator in that case decide there is no oral hearing? Why not documents only? And then set up for like a hearing for 3 days, knowing that the respondent is not going to participate. Because without the participation of the respondent, just think hard, there won't be any need for witness examination. No one is going to be cross-examined. Why would we need a hearing for 3 days or things like that?
Okay, we have our poll finished, so I'm promoting people back. If anyone would like to speak to Jessica's scenario, I mean, we do have we do have 3 people in our poll who have said that parties should not always have a reserved right to demand an oral hearing. Be interesting to hear thoughts from you. I mean, we have a situation where we can also have a situation where the parties have agreed to a documents only arbitration, but there are developments in the arbitration where one of them says, well, actually, I've changed my mind. This issue has come up, and we need to hear a witness, or we need to be able to address the tribunal. What then?
Well, if I may, Raman Zikif again.
Yeah, please do.
Well, perhaps then you need to look into the applicable lex arbitria and then arbitration rules to see whether there is a genuine right of a party to be heard. You know, even though the parties say initially agreed not to have a hearing, and I imagine a party agreeing not to have a hearing would make a lot of caveats to that agreement, and say, well, if circumstances will not change, then there shouldn't be a hearing. And I must agree with Jessica that if a party demands a hearing in the absence of the other one, I mean, it makes very little sense, because you won't be able to cross-examine the opponent's witnesses and experts, etc. So the only thing you are left with is to give an opening statement and direct examination of your own witnesses and experts, although it might be unnecessary because by the time of the hearing, they probably would submit the evidence in writing in any event. And if we look at the arbitrations these days, I think we are moving away from the classic oral hearing we used to have, say, 5-10 years ago, with the opening speeches and closing speeches, etc. So, for example, the closing speeches are substituted with the post-hearing briefs largely these days. So I think it's a gradual move to this, say, without a hearing mode of arbitration, and I think it gets more acceptable globally as well, especially now given this pandemic situation.
Has anyone had experience with Prague rules? I mean, there is that interesting provision where it recognizes that one party can request, but it actually sort of discourages, as a matter of the rules themselves, just encourages the parties to do documents only. How have you found folks that have been involved with that in practice? Is that effective to promote documents only, or do you still have parties insisting on a hearing? Is there anyone that is able to speak to the Prague rules in practice? Okay, so it sounds like we have a terra incognita there. That's something that's going to come up. Well, let's. I've shared the results of the poll, so we. Surprisingly, it looks like we have about 70% or 60% have had experience in documents only arbitrations, perhaps as agreement or simply by default with one party, with the parties not actually insisting on oral hearing. And 90% say we should have a reserved right to an oral hearing. Well, we I think we want to thank everyone for their participation. Hopefully it's been useful to folks to hear the comments of your colleagues and sort of what practices and issues that have arisen. And we wish you the best on your next coffee shop or wherever you're going to now.
Thank you very much, Drew.
We have like, we can use the last 2 minutes if you have any burning questions before, just to cut short your break. No real coffee, I know, though.
Yeah, I have a question, but before I will ask that the participants of this coffee shop may find a link to the next coffee shops in the chat room. Will be much easier to access through the program. But my question is, what if the parties do not request an oral hearing, but consideration on the documents only, but an arbitrator finds that there is a corruption or sham element in the arbitration? Would an arbitrator require to hear the parties or not?
Okay, my experience would be, if you sense there is something wrong there, normally the arbitrator should be more careful by actually, probably it might be right to have an oral hearing to hear the parties and to decide whether there are anything improper. Although, among arbitrators, we also have the discussion whether, we are entitled to say who and who has conducted illegal things or, has breached law, has violated certain laws or regulations. So it's probably, not going that far, but what can you do in a commercial arbitration scenario? You probably still maybe, unless the lex arbitri or the local law of the seat has obligated the arbitrator to report any, for example, criminal offense. Otherwise, everyone is still bound by the confidentiality requirements. So arbitrators may try to find a way to figure out there is something improper there, and may just use, its discretion in determining the evidence to decide the case, rather than saying openly who has breached, the law of the US or the law of Russia. It's probably not something that arbitrator will do, but it does, I think, increase the need for having an oral hearing for the arbitrator to make sure what he or she is deciding and how the arbitrator should decide.
Okay, I think we're at the end of our time. Once again, thank everyone and Roman for the postscriptum. That's an important point that we all need to keep in mind as well, given that arbitration proceedings can be abused for fraudulent purposes. But thank everyone wherever you are, and look forward to seeing you in another session.
Thank you, everyone. Bye.
Bye-bye.